One of the questions I sometimes get from folks about estate planning is this: can I just add one of my children to my financial accounts in my real estate deed to help transfer assets when I die? That's a good question, and it's fraught with risk and problems. Hi, I'm attorney Joel Beck of the Beck Law Firm LLC in Lawrenceville, Georgia. And in today's short video, we'll talk about the perils of joint ownership of accounts with a child for estate planning purposes. So the idea is this: the person wants to add their child's name or one of their child's names to their financial accounts and maybe to their real estate deed because they think it will help transfer assets when they die. Well, there's many potential problems here that most people who ask this question don't think about, and they don't recognize that moving assets into joint ownership with a child is not a true estate plan. So what are the problems or some of the potential problems? Well, here they are. First, an owner of the financial accounts, or as an owner of the financial accounts, the child can withdraw funds from those accounts to use as he or she sees fit for their own purposes, even if that's not your intention. Second, when the accounts are owned as joint tenants with right of survivorship, or even in some other arrangements, these financial accounts, of which the child is now an owner, may become subject to the child's creditors if he gets in financial trouble or gets a big judgment against him or her. Now, instead of having that money to pay for your needs and expenses, your money goes to your child's problems. Third, if you're going to try to obtain Medicaid benefits, then depending on how transfers played out, adding a child as an owner on the financial accounts or on the deed to the house may be seen as an impermissible transfer, making you ineligible for Medicaid benefits for some period of time. Fourth, when you die, the financial accounts owned with the child as a joint tenant with right of survivorship are now fully owned by the child, 100%. They're not going to be distributed through your last will and testament, assuming you had one, and therefore they won't be shared with any other persons, even if you had intended for them to be shared. Now, the child might decide to share with his siblings, but he just might keep it all himself. As the surviving owner, the money legally belongs to the joint owner, 100%. Next, if you transfer real estate into joint ownership with rights of survivorship, that works the same way. When you die, the real estate is then 100% owned by the surviving owner. And of course, we've got the same issues with respect to the property now potentially being subject to the child's creditors if they come into financial trouble or have a judgment against them. So as you can see, moving all of your assets into joint ownership with one child, that may effectively disinherit other family members, and it puts your assets at great risk of loss. The lesson is this: moving assets into joint ownership is not an estate plan. So what do? Well, get a real solid estate plan in place, customized to your situation and taking care of your goals and objectives and needs. Now, I invite you to contact us here at the Beck Law Firm LLC and ask for some free information on estate planning in Georgia. Give us a name and a mailing address, and we'll get this estate planning info kit out in the mail to you right away, no strings attached. When you review it, I think you'll find that estate planning in Georgia is probably easier than you think it is. And you may very well find that it's also more affordable than you think it is. Give us a call today, ask for your free estate planning information kit for estate planning in Georgia, and we'll get it out to you. Of course, if you got other questions, give us a call too. We'd be happy to chat and see if we could be of service to you. Thanks.